So I'm just going to do a really quick intro for the people that are watching this later, or for folks joining who might not be as familiar with Scroobius, as Treya or Tria, apparently you can say it either way, is. but we're a startup too. We're a couple years old now, and we're very focused on increasing diversity in the startup ecosystem by providing the education and resources, tools, and community that founders need to create investor-ready pitch material, so that when you go out and pitch, you're taken seriously and you have a pitch, a deck, and a presentation that's really going to speak to what an investor needs and what an investor is looking for, because it is not an intuitive process. So we have an online learning platform that is full of micro lessons and templates to help you with the scary stuff, like doing a bottom-up market size. Doesn't have to be scary. And we pair it with a number of personalized feedback points to you, so a human tells you what's going on with your own pitch as well. And we will soon, not yet, but soon have an investor-facing platform to display your pitch material. So we'll also get you exposure with relevant investors to hopefully help you establish connections that lead to capital. And so every so often we run really targeted workshops and lunch and learns like we're doing now to help you with different elements of the things that you need to know to run your business effectively and help you get your questions answered by real knowledgeable people in the space. And we have a wonderful partnership with Morse, and every month we do one of these lunch and learns on a different legal topic where super friendly, awesome lawyers come in and give their time and make themselves accessible to teach you about different areas where you really should have a lawyer involved, but I know sometimes it can be intimidating to pay a lawyer to ask a lot of questions. So these are just wonderful sessions. And we are super lucky to have Liz here with us today to talk about the differences between corporate entity structures and also things that have to do with your corporate operations and some of that stuff that you really need to do. And it's, again, just not always clear what that is. And there's a lot of questions around employment and what is a registered agent? Why do I need one? How do I know when to register in a different state? Who's an employee? Who is a contractor? All that kind of messy stuff. So I am going to hand it over to Liz. She is going to go through a little presentation, and then at the end, we're going to stop recording so that for those of you who have joined us live, you can ask your questions. You can ask personal questions about your own businesses if you want, and it won't be shared publicly like the main part of this presentation. If you have a question that's really relevant to what Liz is talking about, type it in the chat. And Lily, our community lead, and I will monitor that, and we can make sure to call it out if it's really timely there. So with that, I'm going to stop talking. Liz, thank you for joining us.
Thank you so much for having me, Allison. And I definitely want to start by saying I'm really excited to be here. I really believe in the Scroobius mission, and I know my firm as a whole at Morse, we are very excited for our continued partnership with Scroobius. We're very excited to help founders from underrepresented backgrounds get the tools and resources they need to be successful. You guys have really great ideas, and we're excited to just be a little part of that with the Scroobius team. So as Allison said, I'm Liz. I work in the corporate department here at Morse, so I'm a corporate attorney. I help founders and entrepreneurs form their businesses. And so that's, a little bit what we're going to be talking about today. In addition, I also do, general corporate work. I can help, issue options if you, have employees that you want to incentivize. I do financings. I represent both investor side and company side, which I think gives me a really unique eye and lens coming into the documents, kind of having an idea, what both sides might negotiate and where we'd end up, and reasonable things to ask for. And I also do mergers and acquisitions here, both buy side and sell side. So, if you get to the point of exit, that's something that we can also help our clients with, which is really exciting, I think, coming from the viewpoint here that I can help from from the start of the company, from inception, all the way to exit. So it's been really rewarding, and I really enjoy what I do. And again, I'm excited to chat with you guys all today. So if you have any questions, feel free to ask them at the end of the presentation or put them in the chat, and I can try to answer those. So I'd really love to, towards the end of the session, when we kind of get in more of the conversational part, just to learn a little bit more about where you are, for those of you who have attended with us live, in your stage of the business. So I'd be really excited to hear about that. So today we'll be chatting about choice of entity, corporate structure considerations, operations, just important things you need to know as you're starting up your company. So this is just a roadmap of some of the discussion that we'll be talking about. So including, like Allison said, we'll chat a little bit about foreign qualification, where you should incorporate your company, a little bit about the registered agent, and what types of companies we see for the entity structure that investors prefer over others. So with that said, what does it mean to incorporate or form a business? So you're going to register with the Secretary of State. The business and the founders will become separate, and you'll have limited liability protection. So when you register with the Secretary of State, you would do that by filing a certificate of incorporation, articles of organization, or a certificate of organization, depending on if it's an LLC or a corporation. So you would go from being a sole proprietorship, which means you're just operating the company as you are. So if I was selling cupcakes and I just kind of started up a business, I didn't really form it officially yet, that I would be considered a sole proprietorship. I'm just kind of running a business on my own. I'm not a legal entity. So at this point, once you register, you would go from that to being a legally recognized entity with the state. The business and the founders will become separate. So this is really important. This deals with your limited liability protection. So this means that you're going to have different protections because now you are no longer considered, it's not just Liz's Cupcakes, but now it's maybe Liz's Cupcakes Inc. That is the business. I am separate from the business. I might be an owner of the business, but say if someone comes into my restaurant and they slip and they fall and they want to sue the company, a lot of that is really going to be the company getting sued, for the assets of the company versus them coming and getting my personal assets. This does change, however, if you do something called piercing the corporate veil. So this is usually triggered by egregious activity, which means they could come directly after me if I did something like if I put something bad in the cupcakes intentionally to get someone sick, then that would be piercing the corporate veil. One of the biggest ways we see the corporate veil pierced is if you commingle funds with the company. So if you have your personal bank account and you also have company funds and you're putting those in and out, you're taking out of company funds money for you to go on a personal trip. So those things would easily pierce the corporate veil. And so you wouldn't be able to rely on that limited liability protection, because if you think about it, you're not really separate from the company anymore. You've kind of commingled yourself as one again. And then so going on to the bank account part that I was just chatting about, one of the first things that I usually recommend once we form a company for founders is that you file what's called an SS4, and this will get you your EIN number. The EIN number is essentially like a social security number, but it's for the entity. And once you have that in hand, you can go over to your local bank and open up a bank account for the company specifically. And then from there on, you just want to keep the company funds separate. Anything that comes in, a check for the company, put that inside the company account instead of your own. Okay, so which type of entity should you choose? So sole proprietorship, we just chatted about, it's not really a real entity. This is kind of just what you start out as. And as you just heard, since you don't have limited liability protection, it's smart to move away from that. We'll briefly talk about these other entities listed here: partnership, LLC, corporations, And we'll also go over some of these considerations, liability tax, when it comes to investors, number and types of owners, the preference of investors' cost, and we'll talk a little bit about where has the better court systems as well for companies. So we've already chatted about sole proprietorship. Partnership differs because it's pass-through tax treatment. You only have to file information on your tax return, and the taxes are reported directly on your personal tax returns. There's no limit on the number of types of owners. All partners can participate in the business. There's shared liability among the partners, which I think is a key thing. It's not an investor favored form. And it can be formed orally or through actions, like if you have a partnership agreement. The S Corp is another type of corporation. You might hear about this often, easy pass-through tax treatment, so it's easy on your tax returns. There is limited liability protection, which is really helpful, but it's also not an investor-favored form, and the reason is because there's a limit on the number and types of owners. So the limitation is that you must be a US resident in order to invest in an S Corp. Nowadays, you might see a lot of international investments in companies. I certainly do. And so this would prohibit you from getting those investment funds. In addition, there's also a limit on the number of owners. It's limited at 100. So you might think early on, starting off your company, I'm never going to have 100 investors. That sounds outrageous. But the reality is, you know, if you end up going down the road, getting angel investment, that's a lot of individual investors putting money in. We do have companies that are clients that have easily over 100 stockholders. So it's something to keep in mind when you're forming the company. And in addition, it's one class of stock. So a lot of the times we'll see as companies grow that they want to issue multiple different series of stock. That way they can give preferential rights to someone who's putting in a lot more money down the road. That you would be prohibited from that with an S Corp.
Liz,
in addition, yep, sorry, go ahead. Yep.
Sorry, I thought it was a good time to jump in. So we have a question in the chat, and then I have a question for you too. So one question is, could you just explain why it's called a subchapter, what the subchapter means?
So that's a good question. So I believe that ties in with where it falls under the tax code. But for us on the corporate side, you know, we kind of just go by, you know, S Corp, C Corp, B Corp. So I could look in a little bit more for that too, but I think it deals with where it falls into for the tax code.
And then my other question I want to throw at you is, if you did an equity crowdfund and there were more than 100 investors in your crowdfund campaign, do they count individually, or does that crowdfund count as one investor?
So that's a good question. So we see, for example, even different angel investor groups, you know, in the Boston area who are investing. For them, even though there's this one giant title, when they come in and invest on your cap table, they are each individually listed. So for example, you know, if you have one company that's even doing all the negotiating of the documents, by the time that it will go onto your cap table, each person is going to be considered a stockholder. And they're each individually putting in money, so that would make sense. Different platforms might have, you know, different things, but that's typically what I see, that they're all individually listed on there. But again, maybe if a different crowdfunding campaign could have a different rule where it's one thing, and maybe at the end of the day, then they give all the rights and, you know, any sort of dividends or something, maybe they divvy up at the end of the day. Another thing with the S Corp too is that it will bust what we call 1202 qualified small business stock tax treatment. And so that permits shareholders of certain qualified small businesses to exclude a significant portion of associated capital gains when selling or exchanging stock if the shares are held for over 5 years, and they have to meet like a bunch of different different rules, but so that's just another thing to keep in mind of why the S Corp sometimes is not a favored corporation. Okay. The next entity is the LLC. So we see LLCs very frequently. There's pass-through tax treatment. There's no limit on the number or types of owners. So there's a lot of flexibility here. All owners do have limited liability protection. We see LLCs as being really great. They are really heavily contract-based. Which is nice. I mean, you'll still have to follow the statutes that apply for LLCs, but there's a lot more flexibility because a lot of things are, written inside of your LLC company agreement. And so there's a lot more flexibility there. Investors can invest in this. As I said, there's no limit on numbers or types of owners. It's still not as investor favored as the C Corp, and I'll go over that in a little bit why. With the pass-through tax treatment, it is pretty easy. You can file your losses or gains right on your own individual taxes just by filling out the Schedule K-1. And the investments in LLCs might cause some tax problems for investors if they're with a venture capital fund. Because if the VC fund has any sort of tax exempt partners that can't receive active trade or business income due to their tax exempt status. So that's kind of one of the reasons why it might not be as good as a C Corp. Going next to the C Corp, so there's limited liability protection for the stockholders. There's no limit on the number or types of owners. So you could have a venture capital strategic investor fund come in and invest, any sort of entity. You could have a non-US citizen invest. You could have 200 investors. So there's really a lot of flexibility here. There's taxation at both the entity level and the shareholder level if dividends are paid out to the shareholders. It's definitely an investor favorite entity type. A lot of the time we'll actually see investors want to invest specifically in a Delaware C Corp. So it's very, very common to see the C Corp because there's so much flexibility for your investors when putting in funds. It's controlled by a board of directors. So with all your corporate governance, you'll need board approval for a lot of the things that you do. So for example, if you are amending a charter, if you are adding on more board members, if you are adding on officers who are going to control the day-to-day of the entity, that's all needs board approval. There's also stockholders. Stockholders would be the owners or shareholders. If you're in Massachusetts, we call them the same exact thing. And those are the owners in a corporation, a C Corp. It's easy to grant multiple classes of stock with different rights and different share prices. So unlike the S Corp that we were talking about, where you just have that one class of stock, with the C Corp, you could have multiple different levels of stock. And we see that often when we have a lot of investors coming in and putting in a lot of money, maybe a couple $1 million towards a later stage of a company. They want preferential rights. They want maybe better liquidation rights or anti-dilution or what have you, when the company sells or dissolves. And so they want some sort of protections. And so it's really nice to be able to have the flexibility here with the multiple classes of stock. It's also easy to grant stock options to incentivize employees. So stock options, as you might know, are options that you can grant to your employees. You can do incentive stock options, which have tax benefits, or I should say are favorable when you exercise with tax. For employees, there's also non-incentive stock options, which can be granted to advisors or consultants. And granting options are really great because you can incentivize an employee or consultant to stay with the company longer. So you're giving someone a little bit of skin in the game, because if the vesting of their option occurs, so you can set up different vesting schedules, maybe over 4-year time is what we typically see. So once they might want to stay on for that whole 4 years. That way they get the whole amount of stock in the company, that ownership. So they feel like they have more skin in the game. It's a great way to incentivize employees. And there's also potential for 1202 stock tax benefits that we were chatting about before. So this is the investor favored entity. Going over to the, yep.
Before, oh, there I am. Hello. You may be getting to this, but because we just talked about the two or the three entities, the two flavors of the corporations and the LLC. But like in my practice, I work with a lot of creative entrepreneurs, and they are like, it's just me, but I don't want my house to get taken if I don't know, get sued for something. So they create an LLC, and they kind of, a lot of people I work with, they kind of accidentally start these companies, right? So they're like, oh, now everyone wants to buy my product. I have to hire people, and now I want investors. So let's just assume Massachusetts, like, so at what point and how would those people need, like, so they come to us, they come to me, I come to you because they've come to me, right? Because they've got this LLC, and now the investors are like, oh, but it's all, we don't want an LLC. Like, what do they do? Is it hard? Is it expensive? And like, at what point do you wait until an investor is like, here's $1 million, but millions of dollars, but you have to change your corporate structure? Or is there like some threshold where it's like, okay, now it's time to either, what do? Do you shut down the LLC, or can you convert it? What do you do?
Yeah, great question, Amanda. So we see this happen a lot. A lot of the times we'll have people come to us, they want to form a company. They're not sure if they want investors. They, like you said, they really just want that limited liability protection. They want to be able to sign as the president of the company, not, just in their individual capacity anymore. They're not really sure what they're going to do with it down the road. And so a lot of the times the LLC entity will make sense for their beginning stages. If they're really not sure what they want to do. The LLC is very flexible, where you can change your entity structure down the road from an LLC to a C Corp. So that is something that you can definitely do. We do conversions here all the time. It's called converting to a C Corp. You can even, convert from a Massachusetts LLC to a Delaware C Corp when you make that decision that you have investors coming in. It's certainly a lot easier to start off as a C Corp if you want a lot of, big investors, or you're not sure of the number of investors you want. You can still get investors with LLCs. We do have that happen all the time too. Just, the C Corp, because of the flexibility, will be definitely more favored. But yeah, you can definitely convert it. We can take care of that. It's not really that expensive to do that. Certainly, if you start off as a C Corp first, you'll save money because you don't have to do the conversion down the road. But yeah, it's really not a problem. It's something we can easily take care of and handle.
Quick,
and the
right? It's like,
done quickly.
Yeah. It's a paperwork thing, right? So if you've got like investors knocking on your door, but this is one thing on your list that you need to deal with, it's not like a months long process going to delay everything. I think sometimes people are like, anything involving lawyers and the government must clearly take forever. But it's just a paperwork situation, right?
Yeah, that's exactly right. It's just a paperwork situation. It's something that we can quickly do. Usually between, us drafting the documents and doing the proper filings, it's usually a couple days. So not to worry if you're in that situation.
Amanda, I can share with you, I went through this at my last company. Prior to this, I had launched to run a startup medical device company where we started as a Massachusetts LLC and converted to a Delaware C Corp. And we did it because when we got our first institutional investor, they said, we don't invest in anything but Delaware C Corp, so you have to change. The one word of caution I'll give you is, I believe, Liz, correct me if I'm wrong, I think we got a new EIN number. And at some point, somebody entered the old EIN number on an IRS document, and it haunted us for the rest of the life of the company. So just make sure that you don't mix up the EIN numbers.
I think
That's
that's also
really
a
good
good
advice.
PSA, Allison, about, of course, you need a lawyer when you're doing all this, but you also need a good accountant when you're doing all of this, right? I'll
Yes.
put that plug in for not Liz.
And Treya, yeah?
Yes, I have a question. We are a Georgia LLC and we're rebranding. So now we are thinking about, do we convert to a Delaware C Corp? Or do we just establish a C Corp, a new one?
Yeah, so that's a good question, and I think it'll take, getting to know the company a little bit more and, the specific situation at hand. But if you have an investor who's saying that they want you to be a Delaware C Corp, you could convert from a Georgia LLC to a Delaware C Corp. And then what I'd recommend you do, which we'll talk about a little bit later in the program, is foreign qualify in Georgia, so that way you still are qualified to conduct business there as well. But it's certainly something that you could do. Absolutely.
Okay, so but the benefits and what if we start a new C Corp and keep the LLC in Georgia is that would my tax account, he would advise me on that, right?
Yeah, exactly. So, you could certainly chat with your accountant about that to see if it makes sense to keep the, two separate entities. Maybe they'll be doing different things. If they're going to be related, maybe you convert so that way you just have the one. So it's definitely something to chat with your accountant about to see what makes sense.
Okay,
Yeah, absolutely.
Yes, thank
But
you.
both options are a possibility.
Thank you.
Absolutely. So the public benefit corporation, this is a little bit more of a rarer model, I would say. And so, a lot of investors aren't always fully familiar with the public benefit corp. So just something to kind of keep in mind, but it must have a public benefit purpose. It must make a material positive impact on society and the environment. It requires periodic reporting of social and environmental performance. It's a highly regulated corporation, so just keep that in mind. If this is something you're looking to do, you might need a couple extra hands on staff to be able to help you make sure that you're doing all of the required reportings. It must have an explicit mission to have goals other than maximizing profits, which is different than your traditional C corporation, which you're looking to maximize the profits for your shareholders. It's a unique model. It's not available in every state. The last time I checked, it was available currently in 37 states, including Massachusetts. But there's, certain states that it's just not available in. So it's, again, something to kind of keep in mind if this is something you're considering. And benefit corporations can also seek what's called a B Corp certification. And you might see this sometimes on different websites. A B Corp certification, it refers to a third-party certification. It's based upon the company's verified performance and other metrics that deal with all of these things that we're just chatting about the impact it makes on society, the environment, the reporting that's being done. In order to also have a B Corp certification, there's a lot of accountability, transparency, measurable social and environmental performance that you have to have. So it's something that a public benefit corp can apply for. So going on to just a very high level, I'm not going to put myself out there as a tax attorney, but just a very high level of some tax considerations. So for the corporations, we were talking about dividends as income. So that's, if dividends are declared. For the LLCs, we were chatting about how you can, it's more of the pass-through. So you just put that rate on your own tax returns with the Schedule K-1. So just, different types of taxings here that your accountant can certainly help you with. So where to incorporate, and Trey, I think this kind of goes a little bit what we were chatting about before. Delaware is considered the gold standard. And that's because Delaware, it has its own special court system. It's got the Court of Chancery. So when you bring a case for, in corporate, if something happens with your business, if it's in really any other state, they have different court systems that you have to go through, and it could take a while. In Delaware, things are a little bit more speedy. They have what's called the Court of Chancery. It's dedicated to corporations. And so it's, you know, a little bit more speedy, but they also have really well-defined case law and statutory law. A lot of the times you'll see people looking towards what has Delaware done? What has Delaware ruled on? So being able to just incorporate there, you have the benefit of choosing, you know, that for your law in your contracts, and being able to, you know, have the Delaware judges be able to rule on, you know, using all of their knowledge, the wealth of knowledge. So many corporations incorporate in Delaware. If you incorporate in Delaware, one thing I'd say, you know, is that you want to foreign qualify in the state that you're actually conducting business in. And so we'll talk about that in a minute as well. Where else do people incorporate? The state of operation. So as you said, it could be Georgia, it could be Massachusetts. It really could be, you know, any state. People like to sometimes just do it in their own state of operation. Maybe you are running an art business, or, you know, just a services business, and you are, you know, you don't really want other investors in your company. You want to be able to just have the limited liability protection, be able to operate as a business. Maybe the state of operation that you're in makes the most sense. It would be less administrative burden if you think about it, because you wouldn't have to form in Delaware and foreign qualify somewhere else. You would have less annual reports and taxes that you would have to pay, not to two states, but now just to your state of operation, or, you know, wherever else if you did have to foreign qualify somewhere. So, you know, it's something certainly to think about. When we go through and we have new clients, we really try to discuss where they want to go in the future, you know, for investments or exit strategy, and really just trying to see, you know, what you're trying to do, you know, today. What are your goals for the business? So all these things really, including, you know, where to incorporate, are really taken into consideration. With foreign qualification, so what does it mean to foreign qualify? So foreign qualify, it's not an international term. It actually means that you're qualifying to do business in a state other than the state that you've formed or incorporated in. So for example, if you incorporated in Delaware, but your operations are in Massachusetts, your employees, your offices are in Massachusetts, you should foreign qualify in Massachusetts, meaning that you're telling the state, I'm conducting business here. You're on record, you're paying, you know, any sort of, you know, franchise taxes or annual reports that you're making to the state. So different things trigger foreign qualification in different states. It's not just, you know, a blanket statement across the board. There's no, you know, blue line rule. So in different states, you know, it could be, you know, office and employees that usually triggers almost in every state. But sometimes it can be just, you know, the amount of business that you're doing in a state. If you're doing a lot of business in one state, that you might be recommended to foreign qualify there. When you foreign qualify, you have to pay a foreign qualification fee. So in Massachusetts, it varies. It's about currently around, you know, $390 for a corp and $520 for an LLC. But again, I'm sure that'll change, you know, over time. In addition, on top of that, you'd have to pay the ongoing fees that we were chatting about in order to maintain good standing. And so that, I believe, in Massachusetts is approximately around $125 right now. So what if you don't foreign qualify, but you should have? We get this question a lot where people are like, what if I know I should foreign qualify. I know I've got a lot of employees working out of an office here in Massachusetts, but I don't want to. Like it's costly and I don't really have the funds. We have seen people try to weigh this cost risk benefit situation. We would, of course, as attorneys, we like to err on the side of caution. We would always recommend that you do foreign qualify. There are actually a lot of fees that could come into play if you don't foreign qualify when you should. So what we'd recommend is that you foreign qualify the year that you start doing business inside of that state. And then, you know, it would just be really the minimum fees that are required. If you don't do that, what happens is there'll be a fee that's determined by $500 for each year the entity transacted business inside of the state. In addition, you'd have to pay the annual reports for those years, which could be around $150 in addition for each of those years. So it's just, and then you'd have to pay, the regular foreign qualification fee as well. So as you can see, it could really add up. I would definitely recommend foreign qualifying. I think the cost and benefits, really do outweigh the back end if you don't. So we also get the question a lot when to incorporate. A lot of people think, incorporating, it does have some costs associated with it. So a lot of people say, do I have to incorporate now? Can I just continue to act as a sole proprietor? So as we chatted about before, that limited liability protection is really important. So I would always recommend that you incorporate before opening up a storefront. Before signing any contracts, you should be signing contracts on behalf of the business. Once you create that business, before taking on any investment, investors will want to see that you are incorporated, and you will want to be too, to protect yourself and the company. And before dealing with any third parties, so if you're going to be doing any work with third parties, try to protect yourself with that limited liability protection. So just quickly, I was just going to go over, I know we're starting to run out of a little time here too, just some more of the cost and just what some of those initial documents look like for LLCs and C Corps, since those are the two prominent entities that we see. So for a C Corp, typically you'll want to check first to see if the name is available. You could reserve the name for a set period of time by doing what's called a DBA, filing a DBA, doing business as, to reserve the name. But then once you file, you would file your charter. So it's called a certificate of incorporation in Delaware, or the articles of organization in Massachusetts, or just to be very confusing, we refer to it shorthand as charter. So, people ask us all the time, what are the difference of these documents? They're all really the same. Then there's the bylaws. These are the rules of the road. This is, how you're going to operate your corporation. This lists out the duties of your directors, and it will put in, for board of director meetings, you need to give, so much time advance notice before that. So it'll list different things like that. We call it the rules of the road, the bylaws. You'll also want, and we were chatting about this a little bit before when we started this, proper consents in place. So if you're gonna, we call it an incorporator's consent. It approves the charter, the bylaws, it elects the first director. A lot of the time we'll just see it, be just one person will be the director at first, just the president of the corporation. And then after that, the director, once elected, will do another set of approvals to approve things like ratifying the charter that was filed, approve a form of stock certificate. They can elect officers who will run the day-to-day. So your secretary, your treasurer, your president, approve opening up bank accounts. The initial stock issuance to the first stockholder will be the owner. Typically, again, we see that a lot of the times it's the same one person. You'll have a subscription agreement, which means that they're purchasing the initial shares of the corporation. And then, as we said before, make sure you do file your SS4 to get that EIN. For the LLC, it's a little bit different. Again, you'd want to probably, you definitely check to see if the name is available. You could also file a DBA to reserve the name if you, knew that you weren't going to be able to actually create the corporation or the LLC for a little bit. Certificate of organization. You'd have an operating agreement. The operating agreement kind of acts as your rules of the road. So I always think of this, if we're looking, kind of compared to the C Corp, I would almost compare it as like the bylaws together with the charter. It just kind of lists out everything. It lists out, the principal place of business, the number of units. So instead of stock, you have units. That's your way of ownership. So it'll list out that, it'll list out, the members and different things that, the board of managers will have to do. You'll have an initial consent of managers. So instead of being called directors, they're called managers. or it can be member run, and the members are the owners. And then again, make sure you do your SS4 for an EIN. As far as talking about cost, I'll just quickly go over that. So there's different fees, and again, they're going to change from time to time. Plus, you have to add in legal costs if you're going to have someone draft those documents for you, or if you're going to have a filing person, like a corporate vendor, do your filings to help you as well. There's usually a separate cost there, but the state fee for forming a Delaware LLC is currently about $90. For a Delaware C Corp, it's currently about $89. And then they add on additional $9 per page for the charter documents. And if you have a high number of stock, it can certainly increase as well. That this is just, for the minimum amount of stock. A Massachusetts LLC formation would be about $520. For a Massachusetts C Corp, about $265. For a Delaware C Corp, we already chatted about that, but just for the foreign qualification, so it's about $390 for the Corp and about $520 for an LLC just to foreign qualify it. So, and then you have, after that, so these are all your formation costs. Annually, you'll have your annual reports to pay, which vary, on the number of assets and the value of the stock. So sometimes it can be low as $175, if it's a small starting out corporation, and sometimes it can be quite higher. Annual report for Delaware LLC is about $300 currently. So again, that's just very high level pricing, and a lot of these pricings, and you can keep to date with them. Well, you could just look right on the Secretary of State website for Massachusetts, Delaware, Georgia, whatever state you might be in, to see what those current costs are. So let's talk a little bit about registered agent. I know we're running out of time here. So a registered agent it's the company's official point of contact with the state. Your registered agent will be available to receive documents on behalf of the corporation and forward them to the appropriate party at the company. So for example, if you receive legal documents or a service of process or summons, the state needs to be able to communicate with you and send you these documents. And of course, you need to reply. So your registered agent will be the one that will sign off on the documents, send them over to you, make sure the right person gets them. Every business needs one of these for, where you're conducting business. A lot of the time we do see, so for example, say if you form in Delaware, you might not be living in Delaware. You might not have a person who's going to be a registered agent in Delaware. So a lot of the times we do see companies perform these for you. So you can easily just hire a company to do that. The registered agent, something important to keep in mind is that they must have a physical address. A PO box is not accepted for them. And then the registered agent fees can vary. Sometimes we see corporate vendors around about $85 a year, but it can vary. So just real quick, just some important things to keep in mind as you are running your business, no matter really what stage you're in of your business. Absolutely properly classifying your employees and independent contractors. So we see this happen, this could happen at any stage of the business. Sometimes we see it, when you're going to sell a company, the buyer is going to want to make sure that your employees were properly classified. But really early on, you should be taking care of this as well, because there can be a lot of implications, both, with the IRS, the Department of Revenue, if you incorrectly categorize if someone's an independent contractor or an employee. So Massachusetts particularly takes this very seriously, and this is highly regulated here. So just keep in mind, for independent contractors, so they're not subject to minimum wage and overtime laws or tax withholdings, and they don't really get employee benefits. So a lot of the times we'll see companies starting out want to make people independent contractors because it might be more cost effective for them. But if the employee is actually an employee, not an independent contractor, if they are, typically you see if they're working more like full-time hours, if you are their boss and you are dictating, the type of work that they should be doing each day, or, the projects that they're doing, it's, really not as independent. So just, different things to keep in mind. But if you have a question, certainly talk to an employment team to be able to, employment law team to be able to really figure out if someone is employee or independent contractor. If you're on the fence, they likely in Massachusetts would be considered an employee. So just keep that in mind. Protecting your IP is huge too. Again, for any stage of the company, but we recommend getting your documents in order as soon as you start up the company. So what we like to see to protect your IP are all of your employees, or anybody who really touches your IP at the company, signing a proprietary information and assignment of inventions agreement. So what this type of agreement will contain is different confidentiality provisions, but it will also protect, so confidentiality, meaning that they'll keep things confidential and not disclose those, but also agreeing that, any sort of IP that they work on, or maybe that they create during the time of the company, they're agreeing to assign it over to the company. So really, really important. So that way the company itself should own all of the IP. I think the last thing that you want is when you go, to sell a company for, maybe a lot of money down the road, and to find out that someone created this great IP with your company that was helping you, has since left the company, never signed one of these agreements, and now there's a question on who actually owns the IP. So definitely try to avoid that situation and just get documents signed up in the beginning. As we chatted about before, you definitely want the separate bank account for the company and the individuals. You want to foreign qualify in states, just so if you're conducting a lot of business there, that way you avoid any sort of penalties. And you want to show that, the business and the individual are separate. So again, as we chatted about with the bank accounts, but also, when you're signing onto a document, you don't just sign, in your personal name, but sign on behalf of the company, put a signature block there. This is Liz's Cupcakes. I'm signing as the president of Liz's Cupcakes. So just different things like that to keep in mind. And with that said, I think we are all set and out of time, and we're going to stop the recording. And if anybody has any other questions that they want to ask, I'm happy to answer those for our remaining time.
It was great. Thank you so much, Liz.
You're welcome.
No, it was so helpful. And so we do have a question. David has a question about equity and Cliffs investing. So a little bit different than some of the stuff we covered. And I have a resource for him. I'm trying to find on my computer. So he wrote a long thing in the chat